All right, so we're going to start on contract law. So, contracts, I'm going to give you a couple of really easy rules up front that if we followed, we wouldn't have to worry about what we're going to talk about for the next 2 weeks. All right. The first rule is put it in writing. Just put it in writing. That solves a whole lot of confusion down the road for people that want to argue, or have litigation about whether or not they have a contract and what it says and what it means and what it was supposed to say. Just put it in writing. That's the first rule of it. The second rule is that we could have a valid contract, an enforceable contract. So when I say valid contract, I mean one that you can go to court and the court will say, yes, there exists a contract between the two of you, and these are your responsibilities and these are your responsibilities. All right. But just because we have a valid enforceable contract does not necessarily mean that somebody's going to go to court and enforce it. Because, well, let me give you an example. I asked Mike if he will give me a ride home after class. And if he does, I'll pay him $10. All right. He gives me a ride home from class. I get out of the car and say, "I smell you later. You ain't getting your $10." We might have a valid enforceable contract, but is that something he's going to sue me for? Probably not. Why not, Mike? Why it's going to cost you a lot more than $10 to try to enforce that. So we have to think about enforcement of contracts from a real practical standpoint. A valid contract is one that can be enforced in court, but it doesn't necessarily mean that that's the first thing we would do if the contract got breached. Another kind of general upfront rule that I want you to appreciate about contracts is that they're judged by a court based on what's called the objective theory of contracts. All right, what the contract says, what it binds the parties to do, depends on the objective evidence, what's written, what was said, what the actions were that were undertaken, not what was in my mind. I know I said that I was going to pay him $10, but I was just kidding. And he should have known that I wasn't serious. We don't judge contracts in a courtroom that way. Only objective facts would be admitted into evidence. So if Mike sues me for stiffing him on the ride home and we go to court and the judge says, "What's your defense, Mr. Tebow?" And I tell him that we didn't have a real contract because I wasn't serious. And the judge is going to say, "Well, what facts do you have to support that you weren't serious?" Well, I mean, in my mind, I was just joking. Well, what did you say? I said I would pay him $10 to give me a ride home. Did you say you were joking? No. So the court is always going to look at the objective facts and circumstances about what happened. So contract law can be broken down, I think, into four main elements. And this takes a while. So we're going to spend this week on the first two elements and next week on the second two elements. I'll go ahead and tell you all four of them, even though we're not doing all four today. Their agreement. That's the first element. There has to be a valid offer and a valid acceptance of the contract. So you've got agreement. There has to be consideration. That means that each party has to give up something of value or do something of value. Otherwise, it's not a contract, it's a gift. All right, if I tell Mike I'm going to give him $5 and I don't do it, he couldn't sue me on that because there's no consideration for me giving him $5 on Mike's part. Now, if he says, what'd you say? A late fee? He's charging me interest on that. So consideration is the second element. The third element is that the person has to have the capacity to get into a contract, to enter into a contract. So contractual capacity is the third element. And then legality is the fourth element. and basically we'll spend next week on that. But what that means is legality. You can't have you can't make a valid contract to do something that's illegal. Like if Big Worm hires me to sell his weed and he doesn't pay me, I can't sue him on that. We can't. It's lacking the element of legality. Again, we're going to spend a whole week on that, but I just wanted you to have a flavor for kind of what that is. And then after we go through the elements, we're going to talk about some defenses to a contract, because what would any law topic be without us having exceptions and defenses, right? So in your outline, I'm skipping to the part that talks about. Yep. Mm-hmm.
Contractual capacity.
Yep.
You just said ability to enter in a contract. What does that mean?
So we are going. That'll be next week. But just in a nutshell, capacity would mean if I'm in a coma, I don't have the capacity to enter into a contract.
So just the capacity to agree to something or do something.
Right, to bind yourself to something. Very good. So like some people who have developmental disabilities might not have the capacity to enter into a contract. A person who is drunk off his ass might not have the capacity to enter into a contract.
Would somebody like a billionaire and like somebody who barely has shoes to put on their body be able to enter in a contract for like millions of dollars?
Could there be some inequality of bargaining power between, I'm repeating it for my video watchers, between one party who's a billionaire and another party who is basically destitute? It's possible that that person could lack capacity if they were being pressured or they weren't agreeing to something voluntarily, but they were doing it because they felt like they had to. That can negate capacity sometimes. Coercion can definitely negate capacity, for sure. We talked about the the defense of duress before in the context of criminal law, where I think the example was somebody holds a gun to Nana's head. Or no, what did we tell Nana? That we were going to cut her oxygen off if she didn't sign this check to me or something like that. She lacked the criminal intent because she was under duress. Same thing for capacity. I can tell Nana she's either going to give me her bank account or she's going to sign this contract promising to give me her bank account in exchange for me dropping by to see her once a week. And she may not have the capacity because I had put her under duress to do that. Possible. Hard to prove. Not impossible to prove, but hard to prove, because again, when you get to court, under the objective theory of contracts, it's going to, if somebody doesn't have capacity, it's going to have to be obvious to the other person. The other person should have known that the other person lacked capacity. Underage people lack capacity. So that's another thing we'll get into next week, is what happens when a minor makes a contract. All right, so the first element we're looking at is agreement. And that seems pretty elementary to us, that there has to be an agreement in order for there to be a contract. But what do we mean by that? So what do we mean by having a valid offer and a valid acceptance? So I may have my notes out of order here. Yep, well, I skipped over. All right, hold on, these are really out of order.
The place I have it is at the very bottom of page 3.
Where agreement begins?
That's
All right, tell you what, let me look at this real quick. Sometimes these get jumbled in my folder, and it is. But thank you for saying that, because I did start the first 3 minutes of this without it. All right, let's see. I just don't want to be wondering if I've got the right thing for the rest of the class. I'm just going to pull it up a different way. All right, here it is. So we have been through, yeah, so I think somebody had said, did you skip over defenses? So after I talked about the 4 elements of a valid contract, there'll be more defenses than what are listed here, but one of them is obviously voluntary consent. So if the agreement was not voluntary, that would be a defense to whether there was a valid contract or not. Another one would be as to form. So we're going to find out as we go through this that there are some contracts that have to be in writing, not all contracts, but some do. There could be other problems with the form. It might not list the parties correctly, or it might not list the consideration. There's some other things that could make it defective. And we're going to get into that in a little more detail. The section on types of contracts, I do want you to read through that, but we're not going to spend a ton of time in class on that. And so I want to go down to agreement. Section 2, agreement. So obviously, for us to have a valid enforceable contract, there has to be an offer and there has to be an acceptance. I don't get to just decide unilaterally whether or not there's a contract. I can't go tell Theo that he's got to give me a ride home from class today and I'll give him $10 and he has no choice. That is not a valid offer and acceptance. So what does the offer have to be? The offer has to be made seriously. So there has to be serious intent on behalf of the offeror. So if I say to Travis, if you show up in class Thursday, I give you $1 million. Would anybody think that I'm serious about that? Travis might. And what's the court going to look at, Theo? Objectively, whether or not Travis should have thought I was joking or would have known that I was joking or not. So I better not do that. I think he'd still have a hard time with that because he's already required to come to class. But see, he's trying to settle, which is very, very wise. All right, so there has to be a serious intent. There has to be certain or definite terms so that the court could ascertain what the agreement was. So I couldn't say to Theo, if you give me a ride home after class, I'll pay you, I'll make it worth your while. He drops me off at my house. I don't do anything. He sues me. My defense in court would be that I didn't make a valid offer because there were no reasonably certain or definite terms. Give me a ride home and I'll do something for you. We'll figure it out later. Not reasonably definite or certain that a court could ascertain what the contract was about. And then it has to be communicated to the person that the offer is being made to. It seems elementary, but if I tell Theo, I will give you $100 if you give me a ride home after class, and before he says anything, Miss Rabara says, deal. She and I don't have a contract because I didn't make the offer to her. I made the offer to anybody. Hey, if anybody will give me a ride home after class, I'll give them $100. You've all been communicated the offer. So the offer has to be serious in intent, it has to be reasonably certain or definite in its terms, and it has to be communicated to the offeree. So let's look at intent for a second and break that down. What does serious objective intent mean? Well, we're going to use the reasonable person standard again, just like we did when we were looking at negligence. Serious intent is determined by what a reasonable person in the offeree's position would conclude the words or the actions meant. All right. If I offer Theo $10 to give me a ride home in his car after class, a reasonable person in his shoes could understand that he's going to give me a ride home and he's going to get $10, right? If Theo's 5-year-old little brother is in here and I tell him I'll give him $10 to give me a ride home in his car after class, for him to drive me home after class, a reasonable person, a reasonable 5-year-old would not expect that that's a a valid offer because they don't have a car to drive. Now we could, you see where people get in trouble and where litigation comes from. Theo's little brother could say, oh, I know exactly what he meant. I take him home on my big wheel. He just said, drive me home. He didn't say in a car. I'm 5 years old. I might not even be in school yet, but I know what take somebody home in exchange for money means. I get that. So when I told you at the beginning of the class that my first rule was to put everything in writing, that's what I mean by that. Whenever we get into oral contracts or we get kind of vague, I mean, how many times can you think of somebody that you know and you're like, oh, we'll work it out because I know that person knows me. Yeah, it's all well and good until there's a dispute. And then if you have it in writing, then you've got a much easier way of settling your dispute. When are other times when intent may be lacking, when it's not serious? How about if expressions of opinion? I think, Ms. Rabar, I think your car is worth $100,000. Did I make an offer to her? I just expressed an opinion. All right. Statements of future intent. At some point, I'm going to sell this laptop for $20. Mike says, sold. That was a statement of future intent. So that is not a valid offer. It lacks the element of intent, of present intent. Preliminary negotiations. Junior, you interested in buying my car? Yes. What are you asking? I mean, I don't know, maybe 20,000 or something, but I'm open to offers. At this point, we're still just negotiating in preliminary negotiations. No definite concrete offer has been made. So that is not qualified as an offer. Invitations to bid are not offers. You'll see that lots of times with government. Well, they're not the only people that do it, but governments do it a lot where they have to put out something for bid. Hey, I need this road built. I invite you to submit a bid for what you'll do it for. That's not a valid offer. Advertisements are not offers. That sounds a little crazy because what if I pick up the newspaper and it says Best Buy is selling iPhone 15s for $40? It's just an advertisement. The courts will not enforce that as an offer. False advertisements come from when there is a misrepresentation of fact in an advertisement that causes someone to buy it or enter into a contract.
Isn't that what happens when you say that all iPhones are like on the floor are $5, but when you get there and they're normal price? Isn't that a misrepresentation?
That could be. It would.
Then why would an advertisement stating such not be enforceable in court?
It's not enforceable as a contract. False advertising is a tort. It is wrong, but it is a tort. Not you would enforce that by suing the merchant in tort for false advertising fraud, rather than on the basis that y'all had a contract. So there is a remedy. It's just not in contract law. Very good question. And then live and online auctions. Just because you make a bid does not mean when the auctioneer is not offering, they're just taking bids. All right, so that's the.
In an auction.
Yes, ma'am.
Who is making the offer? Is it the auction house?
Great question. Who is making the offer? The buyer's making the offer.
The buyer's making the offer, but like the auction house is offering up the product.
Well.
And does that constitute as an open-ended contract to be decided on the price by the actual auction?
Once the bid is accepted, then there's a contract between the auction house and the buyer. But not until then.
As soon as the bid is won?
The bid has to be, it's established as soon as the bid is won. When they say sold to Annabeth Willett for $5 million, this laptop. Sold. Your bid is the offer, And as the auctioneer, my saying sold is the acceptance. But I'm not making an offer to you. You're making an offer to me that I've accepted. All right, so if we're looking at that there has to be serious intent in an offer, there has to be definite terms in the offer. So let's look at that for a second. We want to identify the parties to a contract. Even when I said, if any student in my class will give me a ride home after class, I'll pay them $100. I've defined the parties as any of you in the class. If I said, I'm looking to pay $100 for anyone to take me home after class, then the parties could be anyone that heard it. If I said something that was more general, like I'd pay $100 to get a ride home from class, that might be a little bit more difficult to determine who the offer was made to, because I didn't really say anybody. Again, that's why we're always going to do what with our contracts? Put it in writing, right? Okay. So we're going to spend 2 weeks basically talking about problems that come up when people don't put things in writing. One of the problems that come up. We could eliminate a lot of what I'm going to talk about this week and next week if you'd put everything in writing. All right, so we're going to identify the party, but we're also going to need to identify with some reasonable certainty the object or the subject matter of our contract, the service to be provided, the good to be sold, the object to be sold. I want to sell my car for $20,000, and then Theo brings a check for $20,000 Thursday to class and says, I'll take the keys to your brand new Porsche. Okay, and he says we had a contract because I said I wanted to sell my car for $20,000. I might could go to court and say, well, Judge, I own 10 cars. There was no way that was a definite offer because Theo could not have known which one of my cars I was offering to sell for $20,000. Maybe not definite enough. The consideration, the amount to be paid, or the service or the action that the other person is going to take, that's got to be spelled out in the offer. Theo, I'll sell you my car for a fair price. That's not definite enough in terms of the consideration. What if I said, Theo, I'll sell you my car for the Kelley Blue Book price? More definite than a fair price, right? We still could haggle over the description of my car and looking up the corresponding Kelley Blue Book price on it. But the more definite the terms are, the more likely you are to have a valid contract. Remember, we think a lot in terms of contracts in terms of I'm going to give you a ride home for $100. Sometimes it's I'll give you a ride home today if you give me a ride home Thursday. It doesn't always have to be for money. You can have a valid contract for both people doing something for the other. You could have a valid contract for not doing something, as long as it's something you have the legal right to do. So like if great aunt Harriet offers 16-year-old Tom $10,000 when he turns 21 if he's never had a drink of alcohol. That's a valid contract because I'm not doing something. I'm refraining from doing something. So forbearance could be consideration. All right, so we want to spell that out. We want that to be definite. And then the time of performance needs to be definite enough that the court can ascertain what the meaning was. Theo, I'll sell you my car for $20,000 when I'm done with it. Okay, that is not very definite in terms of performance of when we're going to actually carry out the terms of our contract. So all those would be defenses to a contract. You could say the offer wasn't definite enough in terms of specifying the parties or the consideration or the services to be performed. There was no serious intent. We just went through all those. You could turn around and use those as defenses in court. All right, when we said that communication of the offer needs to be made to the offeree. The offeree needs to know it. You can't have a bargain if one of the parties doesn't even know that they've entered into a contract. All right, let's say that I make an offer to anyone in the class. I'll pay you $100 to give me a ride home after school. I just said that today. Nobody gives me a ride home today. Could anybody come up on Thursday and say, I accept your offer to pay me $100 to give you a ride home after class? How come, Travis?
You said that specific date.
I did say, did I say that specific day? I don't think I did. If I did say that specific day, oh, maybe I did say today. All right. Well, that's what it would depend on is what the objective words were in my offer. All right. Well, let's say that I said I need a ride home from class today, and I'll pay anybody in this class $100 to drive me home after class today. Nobody takes me up on it right now. But at the end of class, I've decided that I'm going to walk home. I don't want to pay anybody $100 to take me home anymore. Do I still have an open offer to you all by the end of class if I haven't said anything else? Yeah, I do. So the question then becomes, how does the offeree, the person making an offer, how does that person terminate an offer? And there's a lot of different ways. Right. One is by revocation. Hey, I take my offer off the table. The offer is no longer open. That wasn't funny, I don't think.
Why are you dying?
We'll never know. All right. Termination by revocation. I can revoke an offer anytime I want to, except in the situation where I have agreed to hold it open for a period of time. You see this in real estate contracts. I will sell you the house for $400,000, John, and this offer is good through Friday. All right. Then I cannot revoke that offer early. Usually, the person who is getting that extension or that amount of time that the offer remains open, they're usually going to pay something of value to the offeree to leave it open. That's the best way to make sure that the offer stays open. So in real estate contracts, you put down earnest money, right? Okay, I'm not going to pay you the full $400,000. I'm going to go ahead and give you $500 to hold the offer open for a week. Then I have to do it. He's given me consideration. In exchange for me leaving the offer open, he's given me $500 to do it. It would be a little harder if I just said, well, let me take that back. If I told John that I would sell him my house for $400,000 and that offer is good till Friday, but he doesn't give me any consideration for holding it open, then I could turn around tomorrow and tell him that the offer is revoked. Hey, I take that offer back. I know I said I'd leave it open till Friday, but you didn't give me anything in exchange for that, so I'm revoking the offer. It needs to be something given of value in order to have it held open. Termination could also, termination of an offer could also occur by a lapse of time. So, Mike, if I tell you that I'll sell you my car for $20,000, but I need to hear something from you by tomorrow, and it becomes Thursday and I haven't heard anything from you, then my offer's terminated because I told you it was only good through tomorrow.
Where is that?
Lapse of time, where is it in the outline?
Yeah, because I have termination by action of the offer.
Look at C, termination by operation of law. I think I just skipped around. Another way that an offer will be terminated is by destruction of the subject matter. Theo, I'm going to sell you my car for $20,000. I'll give you till Friday to think about it. On the way home today, I totaled the car. It is ruined. My offer is terminated because there's nothing left for you to accept. If I die or become incompetent before you accept, then the offer is terminated. Offers don't have to have a deadline to accept by. I could have just say, Theo, I'll sell you my car for $20,000. And he says, can I think about it? And I say, sure. I mean, if he comes back to me next week and says, I accept, a court is much more likely to find that we've entered into an agreement than if he comes back to me in 10 years and says, I accept, assuming I even still have the car. Mike's question.
So, in a situation where it's like a family member, right? They die, and you have the power of attorney, right? Well, actually, no. They die, and you're the family member's, let's say, son, right? They're deciding to sell the house. They happen to expire. The person's still interested in selling the house. Is there a way for that son to still go ahead and sell the house?
So the question is about a person dies and their son had power of attorney in selling the house. So that brings in a couple of different other different areas of law. So power of attorney is when you give another person the right to act for you, but those expire at death. So if I gave you a power of attorney and I croaked, you can't use it after I die. You can only use a power of attorney up until death. Post-death, in order to have the authority over the dead person's assets, you would need to go to probate court and become the executor or the administrator of that estate. But your question was really about offers. So what happens if the offer is made before death? My dad agrees to sell you his house. Y'all enter into a contract for it. Well, no, we're only talking about offer at this point. My dad offers to sell you his house. You haven't accepted yet. He dies. The offer's terminated.
Even if they have a time limit on it when he does, I'll keep the offer open for 5
And
days.
you paid him to leave it open for 5 days, then that offer might be binding on my dad's estate. I think it would, because there's been an exchange of value for leaving it open. Yes.
If somebody anticipates that they might die, like soon, like they're old or they have like some sort of sickness or whatever, and they say the offer still stands even if I'm like, does the offer still stand or can they not?
So the question is, a person who's close to death says, I'll offer to sell you something and the offer still stands even if I die. No, because an offer terminates when the person dies. You cannot accept it to a person who's no longer living. The acceptance would not be effective that way. Let's see. There was one more situation where I wanted to talk about termination of an offer. Here it is. Mike, will you give me a ride home after class for $10? No, professor, but I'll do it for 20. What's happened to my offer now? That's right. Mike's made a counteroffer. A counteroffer terminates the first offer. So if I tell Mike, no, I will never pay you $20 to give me a ride home, and he says, fine, I'll do it for 10. Do we have a contract? We don't. We don't, because my offer is terminated. When he made the counteroffer, he ended my offer and he made me an offer. Anybody see a problem with was his counteroffer a valid offer? The words were, I'll do it for 20. Do we have any problems with that?
What is it? In a new contract, what is it?
What is it? We've got to have an offer has to be definite in its terms, right? I think if I said to him, will you give me a ride home after class today for $10? and he immediately replies, I'll do it for 20, I think that the court would probably say that the it was in response to what I said. But I would argue that in court if I would argue it in court that I don't know what it is. How am I supposed to know what that is? We don't know what Mike's going to do for $20. I'm just kidding.
You would be the assumed party, like it's just already an assumption because it wasn't specified in the contract.
Well, yeah, you would be suing me, saying he didn't give me $20, or I accepted his offer and then he backed out of it. He breached the contract because he didn't ride home with me and pay me $20. And I would say we never had a contract because I never accepted your offer.
It's still a valid contract because
Not a valid contract. Well, it would if you had said I'll do it for 20 and I said fine, then we've got a contract.
well, what I'm saying is like if it went to court and I was showing you're the assumed party, you're assuming who the contract is directed for.
Yes, that's correct.
So I don't have to state in there.
That's right, because you would bring witnesses in, because I might say, well, how were there definite terms? And you could bring witnesses in and Patrick could come under oath and say, I heard him say to, and looking at everybody in the class, or I heard him say to Mike, will you, whatever. So yeah, you'd need to put on evidence of that if I get in there and I'm like, no, I didn't. And it'd need to be objective evidence, what was said, what the words were said, what the words were that were written, what the actions were. Let's say that we haven't really gotten to this yet, but this is a good point to talk about it. Let's say that I say to Mike, you give me a ride home after class for $10. He says, I'll do it for 20. I say, that's what I do. But I get in his car and he takes me home. I never said yes. I never said no, but my actions would show that I accepted his offer. I got in his car and he took me home. He did his part. So I'd have a hard time telling the judge that the contract was for 10 and not 20 because he said 20. And after that, he performed his half of the deal. Or I didn't. I got in the car. I accepted the consideration that he gave. All right. So getting back to offer for a second, the point where we got off, not off track, but where we got into examples is that a counteroffer terminates an offer and becomes a new offer. Rejection also terminates the offer. So Theo, you give me a ride home, I pay $100, you say no, my offer's terminated. You can't come back later and say, I'll take you up on that offer. Too late. Too late. All right, getting to acceptance. Just like we had to have a definite offer, we need to have an acceptance that's definite enough for the offeror to understand that their offer is being accepted. If I make an offer to Patrick, will you drive me home after class for $100, and he rolls his eyes, that's not a definite, I don't know. I don't know if he is, I don't know what he did. I don't know if he accepted, declined, laughed, counteroffer. I have no idea what he did, but he didn't say yes. If I walk out to his car after class and he lets me get in, he never says anything. He gives me a ride home. I don't pay him because I tell him that he never accepted my offer. What's he going to argue? What are you going to argue in court, Patrick? And you did what? You took me home, right? You never said yes, but your actions accepted the offer. So acceptance could be by action. It can almost never be by silence. All right, so I can't say to Ms. Rabara, if you give me a ride home after class, I'll give you a quarter. And and if you don't say anything, then that will be acceptance of my offer. I can't do that's not fair to do. That's a unilateral. That's me making a deal with myself, right? There has to be a voluntary, some outward sign of acceptance from Jeanne that she, yes, agrees to my offer. Could she say, let's say that I say to Miss Rabara, if you give me a ride home after class, I'll give you $5. And she shakes her head. What about that? Do we have an acceptance there? Who's going to be judging that besides the court? What's the standard we're going to use for whether or not that was acceptance? A reasonable person in my shoes. Is it reasonable that I said that to her? She looked back at me and nodded her head. Is that reasonable for me to assume that she agrees? Yeah. That's what shaking her head means. What if she might, though, could say, I sneezed. I don't know. But do you see how we can get into disputes about this kind of thing when we don't have written contracts? So again, back to my rule is put it in writing. So acceptance could be by verbal acceptance, it could be by written acceptance, or it could be by actions. Like the example we used where I think Patrick never said yes or no to me one way or another, but I walked out to his car, he unlocked my side, I got in, and he took me home. Again, he's accepted my offer by performance. All right, so one thing to take away from this whole deal about offer and acceptance is that I want you to be careful about what you say or write, that it doesn't become an offer when you don't want it to be. So in other words, I want you to think, if I'm discussing a deal or an offer with another person, I need to make sure that they know that this is not an offer if I don't want it to be. What are some things I could say?
This is not an offer.
This is not an offer. Good, exactly. This is my opinion. I'm thinking about selling this. Let's talk about preliminary negotiations, but I'm not making you an offer. We're just talking about it. Those are ways to protect yourself. Same goes for acceptance. If Theo makes me an offer and I say, well, let me think about that. If I accept that, would that mean I would have to do this? Don't accept something and then continue to negotiate the terms. All right? You need to be very clear about whether or not you're making an offer or whether you're accepting somebody else's. All right, so let's go to the element of consideration. So consideration is the value that's given in return for the promise or the value given from the offeror. There needs to be legally sufficient value, and it needs to be a bargain for exchange. We're going to break that down. Legally sufficient value means, well, let me say this a different way. Legally sufficient value does not mean fair value. So courts ordinarily will never get involved in getting somebody out of a deal that they decided they don't like later on. Junior, I will sell you my new car for $1,000. You say, that sounds like a great deal, I accept. We put it in writing. Then I decide that it's a brand new car. It's worth $30,000. I'm just going to sell it to him for $1,000. I want out of that. Hey, judge, that's not a fair deal. You know what the judge is going to tell me? Too bad. This is a free country, and you are free to enter into contracts however you want to, as long as they're legal. Maybe I needed the $1,000 cash right then because I was trying to think of what one of those scam calls are. Your grandson's being held hostage, whatever, unless you wire $1,000. Maybe I needed the $1,000 cash right then. Courts are not getting in the business of going back and deciding if a deal was fair or not. Now, if there was inequity in bargaining power, or there was some duress, or there was one party pressuring the other, then that goes to the issue of capacity. Right? I didn't have the capacity to enter into a contract. That doesn't go to consideration. All right, so what is a legally sufficient value? A promise to do something that one already had no prior legal duty to do. So if I am paid, this is not obviously true, if CSU pays me $1 million to teach business law for the spring semester, and I accept that, I do have an employment contract with CSU, and then Dean Kidder says, I'm going to give you an extra $10,000. She tells me that in the middle of the semester. And I say, oh, thank you so much. That's wonderful. And she doesn't do it. There's consideration missing for that extra $10,000 because I'm already under contract to teach business law for the spring. I'm already bound to do that. Consideration has to be giving up of something that you weren't already bound to do.
So you can't fight for the fact that she did not give you the 10,000 she promised?
No, because we already had an agreement. I'm already legally bound to teach business law spring semester under my employment contract. I didn't give up anything of value. I'm already bound to do that. If she came up to me and said, I'll give you, let's say that my contract ends after spring, and she says, we'll pay you $2 million for next fall. Sure, that's valid because I'm not obligated to teach next fall. We got a new deal. But it basically means you can't have a deal for something and then the other person come along and say, just kidding, I'm going to need more. I'm going to need more to do what we've already agreed to do. All right, so it has to be legally sufficient value, and it has to be a bargained for exchange. Right? These are the elements that distinguish consideration from a gift. If I tell Theo, I'll give you $1 million, that is, we do not have a contract because there's no consideration on Theo's part. If I tell Theo I'll give him $1 million if he comes to class every class period, then that's consideration. He's doing something he's not obligated to do already. He's obligated to come to most of them. It's not all of them. All right. So in your outline, I'm down to the part that says adequacy of consideration. That refers to the fairness of the bargain. And this is the part where the courts are not going to get involved on whether you made a good or a bad deal. Sometimes, if something is just so off that it shocks the conscience, that there's just no way that could have been a fair, I shouldn't say fair, there's no way that was a bargain for knowing voluntary contract, then you might have some other defenses. But that brings in things like fraud, duress, undue influence. It's not really that there's no consideration. It's just that somebody was not willingly doing that.
So it is fraud if you're making a contract.
Fraud.
What's the definition of fraud?
So fraud is a tort. So I might not have the defense in contract law that there wasn't consideration, but I might could sue the person in tort for fraud. I might have the defense of duress or undue influence. It just depends on the facts of the case.
You can't.
You can't.
Fraud under contract.
I'm sorry, you can't, yes.
Like a contract is made under false assumption.
I answered that confusingly. Yes, that would be a defense. Fraud would be a defense as to capacity because you didn't knowingly agree to something because the other person was hiding a material fact from you. It's not a defense in the consideration part of it, but it is a defense to the voluntariness of the contract, for sure.
There's a defense into whether or not the contract is valid.
Yes, but where I'm going is which element of a valid contract does fraud negate? And I think you could say it negates agreement because an agreement needs to be knowing and voluntary and willful, but you also could use capacity in that way.
Also use consideration because fraud makes it to where one side of the bargaining table has more to gain or lose but doesn't know it.
Yeah, I still think that goes more to agreement, to the knowingness of it, but
you're lacking a certain knowing.
I like the argument that you're making on it though. Yeah, I think you would.
Fair.
Yeah, the court is not actually going to say to you, Ms. Willett, which specific element of a contract is lacking here. I mean, you can be like, whichever one you want it to be, Judge. I'm just telling you, there was fraud. Past consideration. So promises made with respect to events that have already happened. That's not present consideration. Theo gives me a ride home today because I asked him if he would. He said, sure, he wouldn't mind doing that. He gives me a ride home. Thursday, I say, I'll give you $5 for giving me that ride the other day. And he says, okay. And then I don't do it. He sues me. We don't have a valid contract. We don't have consideration because the consideration that Theo provided was past. That was before the offer was made. Similarly, when we were talking about definiteness of an offer, the consideration has to be definite also in that it can't be, I'm trying to think of the right way to put this. I have to actually promise to do something. So if I said to you all, if you work hard this semester, I'll give everybody an A. The problem with that is that we don't really know what the consideration is on your part. What is work hard? If I tell my employees, if we have a good year, I'll give everybody a huge bonus. Well, there's a few problems with that statement. One is good year. The other one is huge bonus, right? Those are illusory promises. If the offer is something that really can't be ascertained what it means, then that would lack consideration. All right, so I'm going to close today with an exception to consideration. There are times when you could have all the other elements of a contract, agreement, capacity, legality, and not consideration, and the court could still find an enforceable contract. What the court is really finding is that there's not a contract, but they're going to force the parties to act as if there was one. All right, so Professor, why would you spend an hour telling us what all the elements there has to be in a contract only to tell us at the end of the period that sometimes consideration is not necessary? Here's when that happens. This is promissory estoppel. This is the last part of your outline for today. All right. It is what a plaintiff could go to court and say to get the judge to hold the other party responsible in a contract when consideration is lacking. There has to be a clear and definite promise. Well, let me give you the example first. let's say that I call up the Boys and Girls Club and tell them that I will give them $1 million for their new building. They've been doing a capital campaign for a new building. I know that they need that. They're raising money, and I promise that to them. If tomorrow I say to them, never mind, are they going to have trouble taking me to court to find that we had a contract? They are, because of what element is lacking? Consideration, right. That's exactly right. They haven't done anything. I just made a gift. All right. But in some circumstances, if a promise is made that is clear and definite, I will give you $1 million to build your clubhouse. And it's reasonable that the person that I made the promise to would rely on it. Okay? If I, which I'm not, but if I'm a well-known rich person who gives money around Columbus all the time, and my name is on a building at CSU and somewhere else, is it reasonable for the Boys and Girls Club to rely on my promise? I mean, it's a guy who gives away money. He's promised to give us money. If a homeless person from under the bridge walks into the Boys and Girls Club and offers to give them $1 million to build their new building, that might not be reasonable for them to expect that. But let's say that it was reasonable. And then the person that I made the promise to, if they relied on my promise to their detriment, and the only way that justice could be served is by enforcing a contract where none is, then the court might do so. So what would that look like in my example? Boys and Girls Club, I give you $1 million to build your new building. Great. Thank you so much, Mr. Tebow. We're going to close on a piece of property that we've been looking at. We're going to go ahead and make an offer on that. We're going to get that property under contract. We're going to hire an architect to draw the plans. We're going to go ahead and hire a general contractor. We're going to do some site prep work. Then I try to back out of it. They've relied on my promise to their detriment at that point. They spent money. They entered into a contract to buy land. They engaged an architect. They've spent time relying on my promise. That's a lot more likely to be enforced by the court than if I make the promise of $1 million today and I call them up tomorrow and tell them I was just kidding. They haven't had any time to rely on my promise to their detriment. So the point of all that is that there are situations where a valid contract could be enforced by a court without consideration present. In order for that to happen, there had to be a clear and definite promise. It had to be reasonable for the person to rely on it. And then they have to actually have relied on it to their detriment. And that justice is better served by enforcing that promise. Then in those situations, a court could find that there was a contract without consideration. Yes, I know they have, and I'm trying to think of, I know my example is based on one. I can't give you the exact. I want to see if in my other notes I had written. If I can't find an example, Ken, I'll bring one on Thursday to you. Let's see. I wrote down. No, I'm just trying to think. I'll bring you some real world examples on Thursday because I would like to have those. I know that the gift to the charity is one that's come up before. But the key to all that is it has to be reasonable for them to rely on it, and then they have to actually have some sort of detriment. If I made that promise to the Boys and Girls Club, and a year later they still have not bought any land, spent any money on architect, they haven't done anything to their detriment, then the court's probably not going to enforce that as a contract. It's really only done out of fairness, a sense of justice. It's not fair, Mr. Tebow, that you told them you would give them $1 million and you knew that they were going to go out and buy land and hire a contractor and you knew that they were going to do that. So it's not fair at this point for you to back out of it. That's the situation where promissory estoppel would come in. So when you see that sort of fact pattern, that situation, that is promissory estoppel, and that's essentially a substitute for consideration. All right, so Thursday we're going to do the Wright versus Newman case and the Lucy versus Zemer case. And then we might do some examples, and then I'll probably go ahead and get a jump on legality and enforceability. If we have time left Thursday, I'll go ahead and begin the next lecture. But if I do that, I'll post it for you to have that outline. Anybody have any questions? All right, I will see y'all on Thursday. John, let me tell you something before you go.
I took a peek at my
John.
I didn't see one for CSR.
I haven't put y'all's report grade in yet. I went ahead and gave y'all the grade for your presentation all that. Lucy versus Zemer. Calling on you for that case. So you're gonna read it. You know it, read it, and all that. I'm only calling on you for that case. All right, good deal.